Would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
And that's a dangerous thing to do if you're a federal judge. It's a dangerous thing that you have done as a Solicitor General. You were supposed to represent the people of North Carolina in the legislature. You dumped on the case, didn't you? You purposely tried to lose, didn't you?
Things just got real on Capitol Hill. In one of the most intense nomination hearings yet, Senator John Kennedy didn't hold back, pressing a Democrat nominee with blistering accusations of dishonesty, ethical failure, and betrayal of public trust. If you thought previous confirmations were fireworks, this one was an explosion. From allegations of sabotaging his own client's case to accusations of trying to reverse favorable rulings, Kennedy laid out a case so sharp the nominee was left stammering. And by the end of it, even the nominee's rehearsed responses couldn't stop the truth from cutting through. Stay tuned, and let's dive right in.
Mr. Park, would you lie to this committee to get confirmed?
No, Senator.
You just did, didn't you?
I don't believe so, yeah.
I've spent a lot of time studying your record. You're a bright young man. You're an activist, aren't you?
Senator, I don't think that's a fair description of my record.
Okay. You have a history of substituting your judgment for your client's interests. My impression of your record, and I've studied it carefully, is that when you think you're smarter and more virtuous than your client or the law, you substitute your own judgment. And that's a dangerous thing to do if you're a federal judge. It's a dangerous thing that you have done as a Solicitor General. Berger v. North Carolina, State Conference of the NAACP. The North Carolina legislature, elected by the people, passed a voter ID law. NAACP, as is its right, filed suit to challenge it. You were supposed to represent the people of North Carolina in the legislature. You dumped on the case, didn't you? You purposely tried to lose, didn't you?
Senator, not at all.
Well, your opponents, NAACP, filed a multitude of affidavits and expert opinions. You declined to offer a single expert witness affidavit, didn't you?
Well, Senator, let me clarify. I had no role in the trial proceedings. I'm an appellate lawyer.
Did you and your office decline to file any affidavits whatsoever?
I don't recall, Senator. I believe that is accurate, but again, I was not involved in the case at the time.
I checked. You didn't. The district court ruled for the NAACP. You didn't seek an injunction or a stay, did you?
I believe that's correct.
Yeah,
yes.
I know it's correct. You dumped on the case.
Senator, I don't think that's a fair characterization of what happened.
I do, and I think the facts bear it out. So then you take it up on appeal. In fact, the leadership in the legislature, because you dumped on the case, they tried to intervene. Said, our lawyer is not representing us, for God's sakes. They tried to intervene. The judge said no. So the case goes up on appeal to the Fourth Circuit. The Fourth Circuit reverses the district court, even though you and your colleagues tried to lose the case, and you did. It goes up to the Court of Appeal. Court of Appeal and the Fourth Circuit rules in favor of the state. You're representing the state. You tried to appeal the decision that was in your client's favor, didn't you?
Do you mean the intervention dispute, Senator?
No. You tried to reverse the Fourth Circuit that ruled in your client's favor.
Senator, that is not accurate.
Yes, it is. Yes, it is. You filed a petition for an en-banc review to overrule the panel opinion.
Senator, that's actually inaccurate. That's the intervention dispute. My office, there were 2 parallel appeals, and on the merits of the appeal, which we did appeal the non-entry of a preliminary injunction, and we prevailed on that appeal, working with the legislative defendants in that case.
Okay. School funding case. You and your colleagues were supposed to represent the state in that case. Low-income school districts, as happens in most states, sued the state to force the Republican legislature to increase their funding. You're supposed to represent the state. You and your clients dumped on your client. You and your colleagues dumped on your client again, didn't you?
Senator, as Solicitor General Brasher told this committee a few years ago, the Solicitor General does not make those decisions.
Right. This is what you and your boss said. And it's your boss's words, but I didn't see you objecting. He said, today, quote, I'm going to quote, today, lawyers from my office are arguing that we must invest more money in our public schools so our students can get sound basic public education. Y'all dumped on your client.
What Senator John Kennedy did in this hearing wasn't just impressive, it was necessary. In a time when political theater too often replaces truth, and qualifications are brushed aside in favor of ideology, Kennedy showed the kind of backbone that Americans across the country are craving from their elected officials. He came prepared, not just with questions, but with facts. He didn't rely on headlines or hearsay. He dug into Mr. Park's record, studied the decisions, examined the actions, and laid out a clear pattern of conduct that was impossible to ignore. And when Mr. Park tried to twist the narrative, Kennedy didn't flinch. He cut through the spin like a hot knife through butter. Let's be honest here, this wasn't about scoring points. This was about protecting the integrity of the federal bench. Judges are supposed to be impartial interpreters of the law, not political activists hiding behind a robe. Senator Kennedy exposed that Mr. Park has a long-standing habit of putting personal beliefs and partisan causes ahead of his legal obligations. And if that's how he acted before wearing the robe, what can the American people expect once he's confirmed for life? In a nation built on checks and balances, Kennedy just reminded everyone that confirmation hearings aren't a formality, they're a firewall. A firewall against bad judgment, against quiet deception, and against ideological radicals slipping through the cracks of our democracy. Mr. Park may have been handpicked by a partisan administration looking to stack the courts, but Kennedy wasn't having it. He looked him in the eye and held him accountable line by line, case by case, lie by lie. That's not bullying, that's the job. If you believe in truth, transparency, and real leadership, subscribe now. Because we're not backing down. Not today, not ever.